ready to talk about. Before I start talking, though, he uses this word pedestrian, which I have heard somewhere else and wasn't sure what it meant. So I thought, well, I'll go ahead and look this up in my etymological dictionary. This is from the Chambers um, Dictionary of Etymology. And what etymology does is it tells you what when the word was first used and its meaning when it's broken down into its parts and the origin of its parts. So, pedestrian as an adjective was first used in 1716. When speaking of it, using the word in speaking of writings, it's prosaic, which means without imagination, dull, formed in English from Latin pedester, genitive pedestris, which means plain, prosaic, not elevated, without poetic flights, plus English suffix ian. Greek also has an equivalent word, pesos, earlier pedios, in reference to writing that has the sense of prosaic, plain, commonplace. The literal meaning in English of on foot, going on foot, having to do with walking. That's not the definition that's used in the book, so um, I'm not going to read all that. So when he uses the word pedestrian, he means it, um, and it's plain writing, dull, okay? So this book is written by a Harvard attorney, a constitutional attorney, and his name is L.H. LaRue. Constitutional law is fiction, narrative, and the rhetoric of authority. Now, that's an interesting statement. Think about that, narrative and the rhetoric of authority. He um, dedicates this book to a man named James Boyd White, and he calls him his mentor and friend. Now, I looked up James Boyd White, and he has a lot of writing also on law that's very interesting. So, if you feel so compelled, look up James Boyd White and read some of his stuff. So, in the preface of this book, he says that he graduated from Harvard and he worked in the Civil Rights Division at the Justice Department. And he had a few mentors who taught him back in 1965 what it meant to practice constitutional law. Okay, so he says, and for insight into the human reality of constitutional law, I owe the most to the good citizens of Mississippi, both black and white, who taught me what was at stake. By the time that those in the department and in Mississippi had finished with me, I knew enough to know that something was wrong with what I had learned at Harvard. Okay, and then he goes on with his introduction, and I'm just going to read some of the stuff from the first part of his first chapter, and I have the pages here if you'd like to also just sort of read through. And if you don't want to listen to the rest of this video, you don't have to, because basically what he's telling you is that case law is so full of rhetoric that it's difficult to pull out what is fact and what's fiction, that most of what you read in case law is fiction. And then he, in his first part, just gives a good idea of what his thesis is, which is what he's writing on. And he gives an example. But if you want to purchase this book, this is what the cover looks like, so you can find it. It was printed in 1995 by L.H. LaRue, a Harvard graduate, okay, who I guess learned that his education had something wrong with it. So this is not page 8, but page 8 is short. So when I get to the next page, you'll see that. See if I'll pull up page 8 fairly quickly. Computer's running pretty slow these days. It's just not wanting to open up. And all of a sudden, it's probably going to open up 10 times. Here we go. I'll quit my email and maybe it'll run faster. Okay, so telling stories. Just try to ignore my little notes. I wrote a lot of these notes before I realized I was going to do book reviews, but I think that people like to see things in writing. And I also found out that a lot of people will not sit down and read a book. They won't sit down to read an article. If it's not up on their phone, they just won't even look at it at all. And I found that to be true because I'd post things on social media and people want to know answers to things, but they're not willing to do any work to get them. I've been reading for about 10 years now, maybe a little more, maybe a little less. And so I've found some things that were really interesting. I've spent a lot of money on books that I absolutely hated. But in the course of doing that, I found some gems, and I feel like this is one of them. So I wanted to share this with anyone out there who's interested in knowing what's going on. Okay. So I encourage you to find this book and read it, whether you read it online, digitally, or find a bookstore to buy it from. The title of this book, Constitutional Law as Fiction, summarizes my thesis, which is that the proud towers of the law are built not on the level bedrock of fact, but on the perplexed terrain of fiction, that judicial opinions are filled with stories that purport to be factual, but instead are fictional, and furthermore, that these fictions could not be eliminated without crippling the legal enterprise. By the way, I acknowledge the ambiguity of fact, fiction, and story, but in due course, I hope to explain what I mean by these words. My claim that legal discourse is made of stories that are fictional will strike many as curious, since legal discourse does not obviously resemble the short story or the novel. For example, a judicial opinion customarily cites other cases that seem to be relevant precedents. Novels and short stories do not usually start by citing precedent. The practice of stating an issue or citing a rule are also central to legal argument, but rarely found in novels or short stories. Indeed, the average judicial opinion follows a standard format that differs sharply from that used by novelists. Consider, for example, the typical opinion in a court, such as the Supreme Court of the United States. It usually begins with the procedural history, a summary of what has happened in the trial court and the intermediate appellate court, and an event history, a summary of the out-of-court facts, namely, the events that generated the case or suit. The order in which these two summaries are presented may vary, but they customarily come at the beginning of the opinion. I can illustrate this common pattern of quoting from Everson v. Board of Education, which I shall return to later in order to illustrate the thesis of law as fiction. The opinion begins as follows, with events first, procedure second. Mr. Justice Black delivered the opinion of the court. A New Jersey statute authorizes its local school districts to make rules and contracts for the transportation of children to and from schools. Lepelli, a township board of education acting pursuant to this statute, authorized reimbursement to parents of money expended by them for bus transportation of their children on regular buses operated by the public transportation system. Part of this money was for the payment of transportation of some children in the community to Catholic parochial schools. These church schools give their students, in addition to secular education, regular religious instruction conforming to the religious tenets and modes of worship of the Catholic faith. The superintendent of these schools is a Catholic priest. The appellant, in this capacity as a district taxpayer, filed suit in a state court challenging the right of the board to reimburse parents of parochial school students. He contended that the statute and the resolution passed pursuant to it by the school board violated both the state and the federal constitutions. The court held that the legislature was without power to authorize such payment under the state constitution. The New Jersey Court of Errors and Appeals reversed, holding that neither the statute nor the resolution passed pursuant to it was in conflict with the state Constitution or the provisions of the federal Constitution in issue. The case here is on appeal. It is also customary for the author of a judicial opinion to state at the beginning of the opinion a summary of the issue presented for decision. Once again, I shall use Justice Black and Everson as an illustration. The only contention here is that the state statute and the resolution, insofar as they authorized reimbursement to parents of children attending parochial schools, violate the federal constitution in these two respects, which to some extent overlap. First, they authorize the state to take by taxation the private property of some and bestow it upon others to be used for their own private purposes. This, it is alleged, violates the Due Process Clause of the 14th Amendment. Second, the statute and the resolution forced inhabitants to pay taxes to help support and maintain schools which are dedicated to and which regularly teach the Catholic faith. This is alleged to be a use of state power to support church schools contrary to the prohibition of the First Amendment, which the 14th Amendment made applicable to the states. In short, judicial opinions do not look like fiction. Their authors do not believe they are writing fiction, and their readers, or other judges, lawyers, law professors, and law students, do not normally imagine that they are reading fiction. Instead of describing their work as writing fiction, most judges would say that deciding cases is their primary responsibility. People bring their disputes to court, and if they are unable to negotiate settlements, they submit their disputes to a judge, or a judge and a jury. As one goes up the judicial ladder, the focus of deciding cases remains, but an additional fiction, declaring and clarifying the law, becomes important. When we get to the United States Supreme Court in a case like Everson, which I have just cited, the responsibility of declaring law becomes primary. In this book, I limit myself to discussing Supreme Court opinions. Those who declare law have an awesome responsibility, especially when they must declare constitutional law. We expect of them, and they expect of themselves, caution, care, and meticulous attention to detail. Look back at the two paragraphs I quoted from Emerson. The procedural and event histories are short and incomplete, but also quite specific and concrete in the details. This quality of meticulous care is normally present in other parts of the standard judicial opinion. Precedents are cited and quoted from with care to get the page number right. The issue is stated in a pedantic, almost fussy manner, and in general, the prose of the opinion is normally perceived as dense and technical. Hugo Black's prose differs from that of most judges by being far more colloquial than is customary, and so Black does not illustrate all of my generalizations. However, I wish to argue that one should not be misled by judicial prose into believing that constitutional law is a technical enterprise. Instead, I suggest that one should listen for that moment in legal discourse when a story is told. These moments are crucial. Judicial opinions must be persuasive if the enterprise of judge-made law is to have the power that it has. Lawyers and judges need to believe in what they do. The spirit and self-confidence of the judiciary rests on the belief in the rectitude of the enterprise. Oh, I want to read that sentence again because remember on his first page in chapter 1, he says, the judicial opinions are filled with stories that purport to be factual, but that instead are fictional, and furthermore, that these fictions could not be eliminated without crippling the legal enterprise. And he calls it an enterprise. And then here he says, the spirit and self-confidence of the judiciary rest on the belief and the rectitude of their enterprise. Okay, so there was a interview by a man who interviewed another man who was part of, I think, the IRS or the commissioner of the IRS or something, where he says, I can't convince you that it's the law because you don't believe me. So this whole system rests on this idea that you believe that these things are law and that you have to abide by them. But laws are just rules, and not all rules are to be followed because some rules are bad. They only become law when people agree and they follow them for a long period of time. And that's the way many of our laws have actually come into being, is that they weren't created by governments or legislatures or anything like that. They were created by people who use trial and error to find out the best ways to do things. And through trial and error, they eliminated the bad things, the things that didn't work, and they found the good things that work, and then they just did those things, and they became a precedence. It became a system, and eventually it became law. There's custom laws, merchant laws, admiralty laws, and all of these old laws that have been around for a long time have been made so through people just using trial and error and common sense to come up with good law. So law through legislation, just because lawyers or Congress is legislating something and telling you that it's the law, doesn't necessarily mean that it is the law, because even in the Constitution, they make rules and regulations that later become law if they're good. If they're not good, then people aren't going to follow them. And that's the whole basis of law. I have a paper that I'll be coming out with and going over it where I explain more of this stuff in detail. That's kind of a work in progress. So it won't be like tomorrow or probably next week, but I am working on it. So look forward to that if you watch my videos. So he continues, since persuasion is so important, my metaphor, law as fiction, is apt. Without persuasion, law could not be law, and without fiction, there would be no persuasion. I hope that the above establishes the topic. If so, let me now state two qualifications on the scope of my inquiry and on how I understand my thesis, law as fiction. First, the phrase law as fiction is intended as a description, and describing law as fiction is merely one of many ways to describe law. For example, we can describe law as a process for settling disputes, or as a way of organizing power, or as an expression of the underlying social structure of our society. In this book, I shall not examine the merits, which are many, of these alternative descriptions. Instead, I shall try to explain my own. And I'd just like to add in here that this is, I believe, the foundation for free market, because the people decide what is good for their societies. It shouldn't come from some place far off called Washington or seat of government or central government or federal government, because they're going to do what's best for themselves and their corporations and the people they get money from, whereas we will do what's best for ourselves and our family and our communities. And so I believe that people like Ron Paul and like this guy, he has a channel called Maneko64. When they talk about the free market, Austrian economics, that's what they're talking about. They're talking about we do what's right for ourselves because we know what's best for us. As long as you don't hurt other people, then everything should work out fine. Okay, and this guy, what he's basically saying and here is that it's a fiction because it's coming from someplace else where they have to persuade you to believe it. Whereas if it's the foundation of your society that you have built yourself, there's no persuasion about it. You do what's right. Um, you do what works, and you do what works for you and your community, and everything else just falls to the side. And that's actually how laws are truly made, not through um, uh, embellished stories. So he continues on. However, it is surely worthwhile to pause and consider a problem of descriptions. There is a fundamental error here that must be avoided. One must avoid the superstition that at any one description will necessarily or logically exclude any other. So he's talking about how, also how, not just how he's writing this, but how case law is embellished so that it makes you believe that one set of ideas or fictions or partial facts are true, and eliminates the others as being true, which he says isn't correct, the correct way to do things or the correct way to look at things, because just by eliminating something doesn't mean you eliminate other things, or just by including one thing doesn't mean everything else is eliminated. So that's what he's describing here. He says, if I describe a man as tall and heavy, I should not be understood as denying that he is graceful and quick. So too, if I describe law as the way those with power have organized and coordinated their power over the rest of us, I should not be understood as denying that law is also a necessary technique for resolving disputes. And that's kind of what I've said, that law should be used as a necessary tool, but those tools need to be built by the people who are actually using them, and should be done by those closest to who are using them. Both descriptions can be true. To be sure, if I say that a man is tall, I have excluded the possibility that he is short. Furthermore, even though a tall man can weigh less than a short man, the odds are that he will not. Thus, the description of a man as tall does not exclude the description that a man is slight, but it does make it less likely. Similarly, two different descriptions of law could be logically compatible, but unlikely. How then should a reader understand my claim that we can describe law as fiction? Are there other descriptions with which it is logically inconsistent, and are there descriptions with which mine could coexist but is not likely to? The thesis of law as fiction can coexist with other theses such as law as power or law as violence. And I like that, law as violence, because a lot of our laws are violence. It just doesn't appear to be so. As the late Robert Cover has argued, for example, one might say that the stories told conceal violence of the law or somehow enable the law's actors to do violence with a good conscience. However, I do not try to work out any such links in this book. Instead, I limit myself to the fictions that are told. I like the fact, though, that he mentions it, that the things that they do or the stories that they tell are like covert violence. Even within these limits and allowing for the possibility of multiple alternative descriptions of law, my thesis that judicial opinions contain fictions that are absolutely essential to the business of judging is inconsistent with one fairly common analysis of judging, which goes somewhat as follows. Those who judge start with rules which they derive from their reading of cases and statutes. Okay, so he says their reading of cases and statutes, so they're interpreting. And I did another video where I show you an article that was written, I believe it was by some law students who were saying that Congress writes in such a way where things can be interpreted. And then the judicial or the agencies that receive those rules and come under those rules also then interpret. And then the judges interpret. And then by the time you get to anything factual, there's nothing there. There's nothing factual there. Okay, so everybody's just doing an interpretation, and then the judges allow for any interpretation to stand because originally the laws are written to be vague. Okay, so, but the rules standing alone are not sufficient. In order to use rules wisely, judges must consider the purposes behind the rules, namely the principles and policies that make the rules appropriate and rational. Giving a citation here is almost foolish, since one could easily assemble a book-length bibliography on the many variations of this standard thesis. So I will limit myself to the book from which I was taught. The standard thesis reflects the obvious, that judges do talk about rules and purposes, but principles and policies, but err in asserting that this rationalistic account of judging subsumes the necessary and sufficient conditions of judging. I assert that stories are necessary. So he's saying the stories are necessary to perpetuate their fictions because the laws are vague. And it's a business. Second, not only is the phase, and I think he meant phrase, law as fiction, just one of the many possible descriptions, it is also merely a description and not an evaluation. I know many people consider the word fiction pejorative. Fact is good and fiction is bad, but I think the truth is more complicated than that. I will not take the high ground and argue that Shakespeare and Sophocles tell more truths than those who purport to be factual. They do, of course, but my thesis is far more pedestrian. So there's that word pedestrian, which means common, common language, plain. And so I shall proceed on a lower level of discourse. The complexity of good and bad in fiction arises from the tangled meaning of this curious word. In this book, I use the word fiction in the same way that it is used in common speech, but with a twist. Let us start with ordinary usage. As I understand our everyday speech, a fiction is a story about something that didn't really happen. This is what he's saying is our law is what our laws are based on, something that didn't really happen. Okay, so the case laws are fictional. The stuff that's written in the laws, if you look at them as being vague and that they're all interpreted by different people, then can you say that there really is any law and there is really anything to adjudicate if nothing ever really happened? So because they're all fiction, your interpretation would be a fiction. And so if a law is written and then it's written to be interpreted, then that makes your interpretation of the law a fiction and makes the law basically meaningless. The American Heritage Dictionary of the English Language puts it more formally. a literary work whose content is produced by the imagination and not necessarily based on fact. Ordinary usage, which I have described informally as a story about something that didn't really happen, is necessarily the place to start, but it would be disastrous to leave it at that. Consider my dictionary statement that a fiction is produced by the imagination and is not necessarily based on fact. This dictionary definition is unsatisfactory because it implies, without clearly stating, a sharp dichotomy between two kinds of stories: those produced by the imaginary and not necessarily based on fact, versus those produced by the imagination and necessarily based on fact. However, this dichotomy may not exist. I'm thinking about, when I read this, I'm thinking about how Congress writes so-called laws that are either imagined and not factual, or imagined but not necessarily not factual. So having facts but still produced by the imagination. Okay, so do they really mean anything? And he continues, however, this dichotomy may not exist. Can we produce stories without using the imagination? And is it possible to have stories that are based solely on facts? If not, then almost all discourse is fictional. Or, if I may put this thesis more cautiously, most discourse is in part fictional. Consider, for example, history. Historians write accounts based on fact, but good historical accounts are also produced by the imagination. When historians try to explain the course of events, they must compare the several different explanations that are possible, and they must try to say why one explanation fits the facts better than another. But where do the explanations come from? The majority of historians do nothing more than struggle with the explanations that their predecessors have bequeathed to them. We honor as great, however, those who extend our knowledge by the strength of their imagination. We honor those whose explanations are new, challenging, and enlightening. American historians who exemplify this trait include Frederick Jackson Turner, whose frontier thesis revolutionized the study of American history, and Francis Parkman, whose vast imaginative powers enabled him to create an exceptionally vivid account of the French and Indian Wars. Furthermore, the imagination is not limited by proposing hypotheses, which the facts then adjudicate. So you have historians giving accounts of history based on their idea or their belief of what happened, and then you have Congress possibly making laws based on, in some parts, those writings of historians, and then you have agencies taking those laws and interpreting them, and then you have judges taking the interpretation of the agency and interpreting the agency's interpretation, and by the time you get to something, you have a bunch of people in prison for no reason at all, because when it comes down to it, all of this stuff is just, for lack of a better term, bullshit. Okay, so what would that life be so simple? The witnesses who wrote the documents that historians use may have been biased, so that one must cross-examine these documents carefully, and one must have a good imagination before one can ask good questions. Even after we accepted certain documents as trustworthy, they may be ambiguous or incomplete on crucial issues, but one cannot be sensitive to ambiguities or absences without imagination. And furthermore, resolving ambiguities and restoring absences are creative, imaginative acts. He uses acts, okay, because that's what Congress passes. Congress passes acts. And at the end of this video, I probably have a few papers I could bring up and show you how what Congress does looks a lot like theater. The same thing that if you were an actor in a theater or in a movie, your your lines that you follow and the things that happen in the story are called acts, and the way the congressional records are written are similar to the way the movie scripts are written for the actors. Okay, they look exactly the same. If all accounts have fictions that cannot be removed, then fact and fiction are not dichotomies. Every story will have some of both. Our honorable ambition may be to present facts, but human limitations will frustrate us. We will never tell a story that is not fictional in part. If this be true, if fact and fiction are necessarily intertwined, then it follows that the word fiction should not be a pejorative. If fiction is necessary, then it is idle to condemn it. However, not all stories are equal. Some are better than others. As we examine the stories that judges tell, we find here too that some are good, some are bad. Judges tell us these stories to persuade us that the path of the law should run one way, not another, and we may be persuaded on some occasion, but not on others. So he's saying that the judges are persuading us to follow the law. Nowadays, like recently, we saw Biden get up and give a speech where he said, that you have to help him, and he needs your help, and he's begging to your emotions to help him out by wearing the mask. Of course, you see now everybody's taking their masks off. Judges tell us these stories to persuade us that the path of the law should run one way, not another, and we may be persuaded on some occasion, but not on others. Furthermore, because sometimes their opinions are just stupid. Furthermore, the ratio of fact to fiction in all story does not correspond to the ratio of truth to falsehood in it. After all, we can never know facts with certainty. We are limited to probabilities. As every lawyer knows, eyewitnesses can be mistaken, and there is a margin of error in laboratory tests. In short, the facts in a story are never simply true. Rather, they must be considered more or less likely. Moreover, even if our facts are probable, they may be incomplete and thus misleading. For example, suppose it to be highly probable that a worker who was fired gave speeches that the boss despised. This short statement is necessarily incomplete. Suppose further that this worker fought with coworkers at the workplace, and note that fact changes the possible stories. In other words, an incomplete set of facts, even if all the details are true to a high degree of probability, will suggest to us a story that is likely to be false. And conversely, just as a mass of facts need not guarantee a true story, imagination need not generate falsity. Nowadays, they tell us that the CDC has regulations, whereas the CDC, Ron Paul has recently said, is a nonprofit organization registered as doing business with the government and regulated by the federal government. It has absolutely no authority over anyone, and it's not in the Constitution, which really is just a big piece of fiction also. They need you to believe it in order for it to have any power. A story only marginally supported by the facts and largely generated by the imagination may yet be true. In its simplest case, imagination can make a lucky guess, which later investigation corroborates. In more complex cases, a discerning imagination may be our only guide to truth. Further investigation may be impossible because the evidence is lost, witnesses may have died, records may have been lost, physical traces may have deteriorated. And if the key facts concern human intention, whether an act was malicious or merely thoughtless, then imagination may be the only possible guide into the workings of human psyche. In the above, I have used the word story without defining it, which I'd like to point out that in many, 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 maybe all government writings, they use words and they don't define them. And without a definite definition to how they mean the word, there's really no way of being able to know what is actually meant. So, without defining words specifically within the context of their writings, you can't know if you're following it factually, if you're following it by your um, idea of what it means, which is a fiction and from your imagination. Such as citizen of the United States is never, never anywhere defined in anything that I can find, um, other than one Congressional Globe paper, which I will see if I can find and bring up at the end of this because it has the transcript written the same way movies are written. So continues, suggested that a story can be true even though largely fictional, but I have not clarified how I am using the word story. Fortunately, to use so casually a key word like story is harmless since legal stories are far less complex than novels, plays, or narrative poems. Judges do not write like Joyce or Borges. Consequently, I think it best to keep the analysis as simple as possible, and I should do so by accepting a straightforward definition that the novelist Reynold Price has asserted. In his discussion of biblical narratives, Price states, "From Genesis, we gather that Adam invented narrative. When God hunts out the human pair after their fall, Adam says, quote, 'I heard your voice in the garden and feared, since I'm naked, and hid myself,' end quote. A chronologically consecutive account of more than one past event with attention to cause and self-defense, thus a narrative." So he says, since Adam was saying, "I hid because I was naked," he just gave himself away. He was defending himself, and it was like he just heard God coming, or he heard his voice, and he got scared and he hid because he was naked. So then God's like, "Well, what did you do?" So that that's an easy way to tell also if someone's lying. Price's elegant summary works for legal stories, all of which attend to chronology, causation, and evaluation. For purposes of this book, nothing more complicated is needed. The foregoing constitutes the abstract part of this introduction. Let me now be more concrete. To illustrate the presence of fiction in the law, I discuss a few of the key cases governing the church-state relationship. I start with an attempt to show the legal discourse about the law and religion includes stories along with other more familiar topics. The familiar topics in the field of law and religion include legal dissection of the leading precedents, philosophical puzzles about the difficulty of defining religion, sociological analysis about the place of religion in American life, political judgment about whether religion divides or unites us, and historical discussions about how things have changed or not changed. The discourse on any of these themes can be broadly theoretical or intensely empirical, but whether theoretical or empirical, a funny thing seems to happen along the way to the conclusion. No matter how a discourse starts, sooner or later the analyst slips into the narrative mode. For instance, even in the writings of Immanuel Kant, narrative is inserted into the blank place where the presumed purely conceptual language of philosophy fails or is missing. And if an abstract thinker like Kant must use narrative, then everyone must. Are these stories mere illustrative embellishments, or are they the deep structure of cognition on which the theory rests as mere superstructure? My own hunch is that the latter is true, although this assertion is not as easily proved or disproved. Instead, let us turn to the legal discourse on law and religion and listen to the stories that are told. And then he goes into some of the stories um, put out by the judges, purporting them to be fact. And in one of them, he goes way back to some early days where he says that the colonists came to America for religious freedom. And he describes this case and how the judge can't really say, even if it is true, he can't really say that the colonists came here just for religious freedom, when colonists came here for a variety of reasons, religious freedom being just one of them. So here I'm going to bring up a congressional globe, and this one, if you want to look it up, is the 33rd Congress, first session, 1854, number 67. And you see here, if you can see it, Mr. Eastman, and Eastman is in capital letters. And this is exactly how it's done when they write the scripts for actors when they go on to do movies or theater. That's how it looks. It's exactly how it looks in capital letters and all that. So when your name's in capital letters, it's as if you're a player in the theater, which is legal, which is your legal person, or your theater person, which is your fiction. And I go over that stuff in another video. So let me see if I can find, and I know I have probably a ton of them here, where it shows the acts. And you've probably seen them in law where it talks about acts, you know, an act to this, or an act to bring this forth into reality. So an act to bring a fiction into reality by having people follow it. So this will take me just a few minutes to find one. I'm sure that most of you know what these look like. The acts of Congress. They're called acts. They are the actors. A legal person, which is a fiction, your all caps name created by the birth certificate in Texas, is VS, I think 109 is the form, and it says right on there it's a legal document. It's a fictional document. It's a fiction. It creates your fiction, you know, and people have called it a variety of things, and it's just a fiction. It's just here's one. Okay, so this is Statute 2, March 3rd, 1825, Chapter 18. An act for arming the militia of the District of Columbia. It's an act done by actors in Congress, which means a group of monkeys, right? And they called it law. So it really means it's a rule. It's a rule. And it's been described that a law is a rule of action. Okay, so it's a rule for actions. It's what you're going to do. And then who is it talking to? Is it talking to real people or is it talking to fictions? If it says all, if it says in here, all persons must abide by, all human beings and all, this and everyone, it's still talking about uh, arming the militia of the District of Columbia. But nowadays they take this out. Even though it still just means District of Columbia, they'll take that out and they'll say an act for arming the militia. And then it says all militia members must be, and then people say, oh, okay, so all the militia. But you didn't see the part where it says of the District of Columbia, but it does that in a lot of things. So it'll say all persons are liable for taxes, but it doesn't tell you that those persons are on federal lands. It doesn't come right out and say it, and it doesn't define a lot of words. It'll define some words, so you think, well, it gives definitions, but it doesn't define all words. And they don't define the citizens of the United States. And citizens of the United States are fictions. The real people are American citizens, which is in this Congressional Globe article where Congress is arguing because they were trying to pass a bill that says white male American citizens of the United States. And this guy, Mr. Howe, wanted white and American marked out because those aren't part of their fictions. So it should say just male citizens of the United States, because male citizens of the United States shown here are the fictions. American citizens are not a fiction. So he's bringing this forward onto the floor to tell them they need to mark some of this stuff out. And then laughter. So there's laughter on the floor. People are laughing. And then Mr. Disney, funny his name, Mr. Disney, says, well, what of it? Because American citizens are not part of the fiction. And he doesn't say that here, that they're not part of the fiction, but he's making a definite distinguishment that white should be marked out because it should include all men. An American should be marked out because it should only include citizens of the United States, which are federal citizens on federal lands, which are officers and employees in accordance with Title V, which has been passed into law. Many titles are not passed into law. So I'm encouraging you to go out and check out some of my other videos and check out this book. Buy it if you have the means to, or find it on the internet. I'm not telling you how to spend your money. If you can find it on the internet and read it, it's pretty good. At least the first half is really good. The second half, it was okay. I didn't like it as much, but the first half I definitely liked and explained a lot. And if you even just watch this video and put it together with some of the other things that I show on my channel here, then I think the bigger picture will start coming into view, and your perception of things hopefully will change a little bit so that you can stop living in the fiction and start living in the real world. And it can be a difficult process for some people. I've found that through talking to people and just trying to bring up these things, even showing them the proofs, that they still have a very difficult time coming to terms with this idea that they've been living in a fiction all their lives, which, I can't say that I necessarily blame them. So please consider liking, sharing, and subscribing. And I especially encourage you to share, because there's people out there that really want this information but don't know where to go to find it. And so you're one of the people that if you're watching this video, you're one of the people that have found this. And so if you share it, hopefully it'll find other people who are looking for it. And nowadays it's hard to get your information out, because when you start putting out this kind of stuff on the big social media platforms, they just delete you. And I was kicked off Facebook and Twitter and Instagram. So I really depend on people helping get the information out by sharing the videos. And I would really appreciate it, because I would like to experience free market and freedom in general in my lifetime. And hopefully your children will be able to have a life full of freedom. Okay, so like, share, subscribe. I'd appreciate it. And you guys have a great day. I hope you enjoyed the video.